My name is Gabriel Miller, and I'm an intern here at Lyles Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Medicare Revocation, Avoiding Common Mistakes and Appealing the Revocation of Your Billing Privilege. Today's presenters are Ashley Morgan and Jennifer Papapanagiotou. Jennifer Papapanagioutou's practice focuses on compliance, regulatory, and transactional matters for a wide array of healthcare providers, including home health and hospice agencies. She has extensive experience in analyzing proposed and existing business arrangements for compliance with federal and state fraud and abuse laws and drafting a wide variety of legal arrangements. Ms. Papapanagiotou is knowledgeable in all aspects of state licensing for home health and hospice providers and in Medicare and Medicaid enrollment, including initial enrollment, changes of ownership, and appeals of revocation actions. Finally, she assists clients with compliance plans, forming new businesses, and addressing Medicare and Medicaid program coverage and reimbursement issues. Ashley Morgan is a partner in Lyles Parker's DC office. Ashley focuses her practice on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. Ms. Morgan represents healthcare providers across the country in connection with a wide variety of health law issues, including coverage disputes, documentation concerns, compliance, medical board complaints, and exclusion/termination issues. She has worked with an assortment of providers, including home health companies and hospice agencies. Ms. Morgan is also a certified professional coder, a certified medical reimbursement specialist, and a certified medical compliance officer. Just a quick reminder, if you have any questions throughout the presentation, please feel free to type them in the chat box, and we will address as many as possible at the end of the presentation. Tomorrow, I will be sending out a copy of the presentation via email. Without further ado, I present your speakers, Ashley Morgan and Jennifer Papapanagiotou.
Thank you, Gabe. This is Jennifer, and let's go ahead and go to the first slide. Thanks, everybody, for joining us today, probably on your lunch hour. Great. So we are going to talk about a bunch of provider enrollment-related topics with kind of a focus on revocation and how you can get revoked. And if you aren't familiar with what revocation means, it's essentially an administrative action by the Medicare program to take away a home health or hospice agency's billing privileges. There are 22 revocation reasons right now. Those are written into regulations at 42 CFR 424.535. And we're going to touch on those. We're going to talk about the easiest ways to lose your Medicare number and how to avoid those problems. And then we'll talk a little bit about appeals of revocation actions, how that process works. And then we're going to wrap up with a discussion about a brand new status that's been created and implemented in regulations that went into effect recently, and that's called the stay of enrollment. It's sort of a step down from revocation or deactivation. So let's go to the next slide, please. All right, as I mentioned, there are 22 revocation reasons. We're going to hit on, I've created some slides that list all of them, but we're going to hit on some of the bigger ones where we see the most activity by CMS. Just briefly touching on the first revocation reason is a catch-all that covers situations that would essentially result in non-compliance with Medicare requirements. I say it's a catch-all because it's used for pretty much anything that doesn't fit in one of the other revocation reasons, but essentially makes you a non-compliant Medicare provider. Second reason is excluded or debarred from a federal program. If the provider itself or any owner, managing employee, authorized or delegated official, medical director, supervising physician, or other healthcare personnel, very broad, are excluded and are continuing to render services through an enrolled provider, it can get the agency revoked. Felony convictions, this has been a huge, huge area of activity, enforcement activity by CMS. They have effectively been able to use data from a bunch of different sources, conviction records, et cetera, to do a lot of cross-matching with the provider enrollment records that exist. And if an owner or managing employee of a provider has had a felony conviction in the last 10 years, that CMS determines to be detrimental to the program or its beneficiaries, they will take away your Medicare enrollment privileges. Obviously, if it's an owner or managing employee that's in this situation, there are actions you can take to address this, but we're going to talk about that a little bit more later on. Been a really active area of revocation. False or misleading information on an application can get you revoked. Usually this is after the fact. Once they've already approved you, they go back, they find something you left out. Usually these are adverse actions, meaning you failed to report an adverse action to them and they discovered it later on, and they will revoke you for including false or misleading information. And I put in here, omitting information is the same as misstating information. And although this says false, and it implies that there's some intention behind people's actions when they fill out an application incorrectly, I would say 99% of the time, this is just something people overlooked. It's something they either didn't know they needed to disclose or forgot to disclose. The fifth reason, on-site review or other reliable evidence that requirements are not met. This is a lot of words to say you failed a site visit. Usually that means that a contracted site visitor for Medicare went to do a status check on your practice location to make sure you were open and operational during your posted hours and was not able to verify that. That's usually when we see a number 5 revocation. Number 6, we never see hardship exception denial or you didn't pay your application fee. Number 7, misuse of a billing number, knowingly let someone else use your billing number. I don't think I've ever had one of those. Let's go to the next slide. And I will say, Ashley and I've been doing Medicare enrollment work since way too long. It's before 2000 and revocation appeals and work for probably the last 15 years. So we see a lot of cases, and they definitely are trends. So number 8 reason, abuse of billing privileges. This has been pretty hot for the last few years. It used to be this was used to revoke agencies who billed for dead people. If you did it more than 3 times, literally more than 3 instances of billing for a deceased beneficiary, they could revoke you. It has expanded well beyond that, and there's a whole other category of revocations under this reason that are for a pattern or practice of billing errors. We'll talk about that in a little more depth later on. Failure to report changes, also a very active revocation reason. This can be failing to report an adverse action or a change in location. Oftentimes, non-compliance with documentation requirements is our next revocation reason. And again, I've never seen one for that. HHA, and I'm going to, capitalization requirements, I believe, is number 11. And again, I've never seen anybody revoked over that reason. Number 12, Medicaid billing privileges revoked. That actually we have seen, and it's been more active in the last 2 or 3 years, basically since COVID. Essentially, if you lose your Medicaid enrollment, Medicaid billing privileges, Medicare will automatically revoke you. There's some finer points to that, but just know that if you have an issue with your state Medicaid program, it will also impact your Medicare enrollment. DEA certificate or state prescribing authority suspension revocation. We've seen a few cases like that, not a lot, but a few. Generally affects licensed providers like physicians, nurse practitioners, and physician assistants. Improper prescribing practices. I've never seen a case where they've revoked over that, but the regulation does exist to do that. Let's go to the next slide. All right, this was a new one. I highlighted it because number 15 is a brand new revocation reason this year. False Claims Act judgments within the last 10 years can get you revoked. This is an interesting one. I'm not going to go into a lot of depth about it because we don't have a lot of information about it other than what is in the regulation itself. It is clear from the regulatory language and from the final rule that was issued that you're not going to get revoked over a settlement of a False Claims Act investigation. But if your case were to go to trial and you are found civilly liable for a False Claims Act violation, that could also get you revoked. Now, I suspect haven't had a False Claims Act case where we've had to negotiate sort of for continued enrollment, and that can actually be really difficult to do because of just the parties that are involved in these things. But This is something I think in our False Claims Act investigations that are ongoing with the Department of Justice in various jurisdictions is something we're probably going to need to be touching on. It's just something to be aware of. 16 is still being reserved for future use. 17, if a debt, if you owe an overpayment to the Medicare program and it's referred to the U.S. Treasury, your billing privileges can be revoked. You can imagine the thinking there. If you owe money to the government, they don't want you to continue to be able to bill and collect services. I've not seen this used yet, but we are very hypersensitive about it because lots and lots of debts get referred to Treasury that shouldn't be. And it even says in the regulatory guidance when this was implemented several years ago, this reasoning came into being during COVID. How the regulation was promulgated and effective then. I've never seen it used, but it is absolutely low-hanging fruit for revocation because so many overpayments get referred to Treasury, and I would say many, many, many of them shouldn't have been. What this says to Ashley and I is if you find yourself receiving a letter saying, I'm the contractor and I'm getting ready to refer a debt to Treasury, or you actually get a letter from Treasury saying we received referral of this debt of money that you owe to the government, you absolutely have to pay attention to it. You need to reach out to your counsel and have them figure out whether that referral was appropriate or not. And if it was, what are you going to do about it? Because it will threaten your Medicare billing privileges. And I do expect at some point CMS is going to start using this. Number 18, revoked under a different name, numerical identifier, or business identity. This was, again, implemented in early 2020. And it's an effort to sort of cross-refer. So if you own multiple healthcare businesses, same owners or overlapping owners or managing employees, they have given themselves the authority to go after every other business that owner or managing employee has some affiliation with. It kind of goes hand in hand with number 19, which is an affiliation that imposes an undue risk. This also came into being during COVID. And essentially, they kind of either one of these can be used in a lot of different situations. Affiliation, though, we are going to talk about a little bit later on. And this is important because it does require some due diligence and data collection for most enrolled providers to know who their owners and managing employees are and know their histories. And we'll talk about that a little bit later on. Billing from a non-compliant location, I'll give you an example of that. It would be a home health or hospice agency that's maintaining a branch or an alternate delivery site that they haven't enrolled. That will get you in trouble on the survey side. It'll also get you in trouble on the enrollment side. Abusive ordering, certifying, referring, or prescribing of Part A or B services, items, or drugs shouldn't really be an issue for home health and hospice. I've never seen this used. 22, patient harm by a physician or eligible professional. Again, not really applicable to home health and hospice. 23, a supplier standard or condition violation. If you're doing home infusion and you are actually enrolling as a home infusion provider, not just relying on your home health enrollment, then this is a standard. It's brand new, just came up this year. Essentially, they're giving themselves the authority, and I really think this is aimed primarily at IDTF and DME providers, to revoke these providers for violating their standards or conditions of participation. Let's go to the next slide. All right, so what are the easiest ways to lose your Medicare number? We like to play the percentages around here. So we want to hit the low-hanging fruit first. So really, they kind of fall into categories: enrollment problems, operation problems, and billing problems. We're going to kind of take these in order. So let's go to the next slide. So enrollment problems. These are things like you're just not maintaining your enrollment record with Medicare the way you're supposed to. You failed to report a change of location, failed to revalidate on time, failed to report an adverse legal action. You have owners or managing employees with felonies. You haven't, things you're supposed to report or be aware of and take action on that you have not. Let's go to the next slide. So reason 5 is another really active revocation reason. And it kind of goes hand in hand with maintaining your enrollment record. Reason 5 was the one I mentioned. This is a situation where if you've relocated your business and you haven't reported that to the Medicare program, and they can't find you when they come out to do a site visit or a survey, that can get you revoked. It's often, reason 5 is often cited with reason 1, it just because it's considered non-compliance with other Medicare requirements as well. So how do you prevent problems like this? And really, this could apply to almost any data you fail to report that you're supposed to keep up to date in your Medicare record. It may fall under a different revocation reason, but kind of the same substantive concepts apply here. So how do you prevent problems like this, enrollment issues? You keep your enrollment records up to date. When we're talking specifically about your, y'all, the best way to avoid problems are to, first and foremost, never use a PO box or a commercial mail service as a practice location, which for home health and hospice is generally not a problem, but I have had physicians who are hospitalists and don't have an office where they see patients that they've had credentialing people tell them, oh, you can just use the UPS store, or you can use, you know, a post office box as your practice location. That's absolutely not okay. There are ways to do that correctly. With home health and hospice, my guidance to them is you absolutely have to keep your address, your practice location addresses and information up to date in your enrollment record. You need to understand your enrollment obligations. You need to keep copies of everything you submit, whether you do paper enrollment applications or you do electronic applications through PACOS. If you're using paper applications, use trackable mail for paper submissions and keep copies of absolutely everything. Keep your tracking information as well, because your obligation is to timely deliver an application to Palmetto, not to say I put it in the mail and assume that it actually got there. If you use PACOS, which most people are using PACOS these days, I highly recommend you print your submission, and I mean the entire application and the submission confirmation after you submit it. There's a way to do that if you follow the instructions on the submission page. The reason being, once you submit something through PACOS, it can be modified and changed by the reviewer at Palmetto, and you won't be able to see those changes or know what changes were made if you don't have copies of the originals. There's no way to go look at historic applications in PACOS. All you can see is whatever the approved record is at the time and the single application that's pending, if there's one pending at the time, but nothing from before that. Let's go to the next slide. Thanks. So the enrollment regulations, the obligations to keep your record up to date are essentially found at 42 CFR 424.510. There's a couple of others that are important as well. And those regulations are general. Most of the guidance on enrollment and how to fill forms out and what they're looking for in certain data fields are in what we call the Program Integrity Manual, and in specifically Chapter 10 of the Program Integrity Manual. The enrollment regulations themselves are really more high level and general in nature, and we get most of our specific guidance is in what we call the PIM, like I said, the Program Integrity Manual. But the obligations in the enrollment regulations are to fill out your application truthfully and completely. The authorized rep that signs that application is attesting that all the information is accurate and that the provider or supplier is aware of and abides by all applicable statutes, regulations, and program instructions. If you want to save yourself time and a lot of heartache, send in all the required attachments with your application, whether that's a paper application or through PACOS where you upload these attachments. Those can include things like copies of your license, copies of your accreditation, proof of your tax ID number, proof of funds if you're submitting an initial home health application that requires proof of capitalization. If you're updating an electronic fund transfer form, you got to send a voided check or a bank letter. Read those instructions in either the paper application or in PACOS carefully to understand what kind of attachments you need to provide. If you don't provide them the first time, they will ask you for them, but you can save yourself some time in review if you kind of know what to send the first time you submit. Only an authorized rep may sign an enrollment application. There are instances also where a delegated official can sign. Those have very, very specific definitions. An authorized rep has to be reported in what we call Section 6 of the enrollment form. Those are the individual owners and managing employees of every organization. And it's defined as an individual who has the authority to bind the provider or supplier, both legally and financially, to the requirements set forth in 42 CFR 424.510. Usually this is an owner or an executive. I have had Palmetto come back and tell me, well, you said this person is the administrator of this agency. Is that someone who meets the legal definition of authorized rep? Sometimes yes, sometimes no. It kind of depends on how they've been reported in Section 6 and what their actual role is with the business. But ordinarily, they need to meet a pretty strict definition, and that's usually an owner or an executive, like a CEO, a CFO, sometimes a COO, a president, vice president, somebody who's a director or officer of the organization is generally sufficient as well. Delegated officials have to be W-2 employees. There's a whole definition of that as well, and they also have to be reported in Section 6. So not just anybody can sign one of these enrollment applications. You are attesting to a lot of things when you do sign one of these. So it's important that those are people in a position of authority and that can legally bind the organization. If a biller or outside credentialing person is preparing applications, or even if your lawyer's helping you prepare applications, my advice is protect yourself. Be sure you, as the owner or managing employee of the organization, review that application and verify that it's correct. Because it's not the credentialing person's or even your lawyer's name that's going on that application to attest that it's accurate. It's going to be the owners or whoever is the authorized representative of the organization. I also strongly advise you never let anybody sign an application for you. Only the authorized rep or delegated individual can sign an application. They have broadened and made it a little bit easier for us to get applications signed. In PACOS, your ability to sign an application is tied to your credentials in the Identity Access and Management System. That's the database where you set up accounts to be able to access PACOS. So it limits who can sign. Paper applications, same people are permitted to sign. They've now allow us to use electronic signatures. So I can have people DocuSign or Adobe sign an application and print that out and submit it, which has been a big help. If you are like me, you do a lot of enrollment applications. Let's go to the next slide. So if you can keep your enrollment record up to date and accurate, you'll go a long way to avoiding any problems under what I call sort of the enrollment related revocation reasons. I mentioned site visits. Site visits are random sometimes, or they are going to be done as part of a pending application. Usually an initial applicant is always going to have a site visit. And anytime you have a change of location, they're going to do a site visit. These are address and operational status checks only, and they are done on providers and suppliers in the moderate and high screening categories. Moderate screening is still done for revalidating home health agencies and hospices. Some of these have changed recently, by the way. The high screening category now includes both new home health agencies, which it did before, and new hospices, and that's new. And any provider or supplier that has previously been revoked and is applying for reactivation. So obviously everybody on this call, if you're revalidating a home health or hospice, you're going to have a site visit. It's not something you're going to necessarily be aware of happening, because generally speaking, they can do these validations from outside. They just want to walk up to your door, see that the lights are on, and if somebody's sitting at the desk during the, if your posted hours are 9 a.m. to 5 p.m., somebody should be there between 9 and 5 and available to receive people from the public, whether that's potential patients or a site inspector like this or a surveyor. If you fail your site visit, your application is going to be denied if it's an initial application. If you're already enrolled and the site visit is part of a revalidation, they will revoke your billing privileges. Now, they will attempt site visits at least twice during your posted hours. Like I said, you're not necessarily going to know that a site inspector has come by. So it's important that you keep your agency staffed appropriately. We're going to talk about that a little bit more later Be aware that fingerprint-based background checks are now required for all new home health and hospices, or revalidating home health and hospices if previously they didn't participate in fingerprinting during the COVID national health emergency because they waived fingerprinting during that period. And other high-risk providers. The trick with fingerprint-based background checks is we can't do those preemptively. We have to wait for Palmetto to send a letter asking for them. And they are done of all owners of 5% or more of an agency. So something to be aware of if you've never been fingerprinted before and you either become an owner or you became an owner during COVID, you may get one of these requests. I've had a lot of trouble with tracking fingerprint requests because they don't send them to the contact person on the enrollment application. Palmetto, bless their hearts, sends a paper letter to generally the correspondence address for the agency. So it's something you have to look for in the mail. If you have someone else handling, or if you're doing enrollment work on your own and you're either revalidating or doing an initial enrollment, my advice is to check in with Palmetto about every 30 days and find out if one of these letters has been issued, if it's something you're expecting to happen. Okay, let's go to the next slide. All right. I wanted to touch on your reporting deadlines for changes in your enrollment record because failing to meet these can sometimes give rise to revocation actions. So changes of ownership, there's a legal definition of that in Medicare's regulations. Those have to be reported within 30 days. And the easiest way to know if you've had a change of ownership is to look at whether the legal entity and tax ID number of the entity changed. So if you have an asset transaction where a seller sells their assets to a buyer, and after the transaction, the owner is a new legal entity with a different tax ID number, then you've had what we call a chow. And that has to be reported to Medicare within 30 days after it happens. If you've had a change of control, that's characterized by Medicare as a change of information. And that is generally equity transactions or equity changes, equity ownership changes. So if you're a corporation and you have a sale of shares of the owners of the corporation to new shareholders, that's a change of control. It could also be adding new investors to an organization or some change in how much each owner owns. Those can be considered changes of control that are reportable within 30 days. If there's a change of authorized or delegated representative, that is also reportable in 30 days. And generally speaking, when you have a chow, that first one, that you've got a different owner after it happens, you're also going to have a change of authorized or delegated rep. Final adverse legal actions, you have 30 days to report those. I will caution anybody reporting final adverse legal action to please talk to your counsel before you do it, because it can result in sort of automatic revocation. And there are other ways that may be better to manage that scenario. If you change, add, or delete a practice location, that has to be reported within 30 days after it happens. Be aware you obviously have licensing requirements to meet when you change, add, or delete practice locations as well. And generally those have to be reported much faster than that, if not in advance. So we often work with providers who are either moving practice locations or adding a branch or an alternate delivery site. And the timelines for those all vary, but Medicare requires them to be reported within 30 days. Any other change to any other section of the CMS 855, whether that's the PACOS online version or the paper application, has to be reported within 90 days. Some of these have changed over the last year. For example, the change in practice location actually used to be 90 days. It is now 30 days. So you need to keep an eye on 42 CFR 424.516, where all of these deadlines are outlined. Let's go to the next slide. Okay, revalidation. You got to be aware of revalidation. Make sure that if you come up for revalidation, you're doing it timely. Revalidation requirements are found at 42 CFR 0.515. Generally speaking, you're required to revalidate every 5 years. A lot of people were delayed during COVID, and their revalidation dates were rescheduled. be aware of that. If you haven't already been asked to revalidate, you can go to the website I link here, the data.cms.gov/revalidation, and check whether you have, if you haven't revalidated yet, you can see whether you've been scheduled for revalidation. They generally will show a revalidation that's due within 6 months on that list. Once you see yourself pop up with a due date, start working on it. Don't wait. If they haven't heard or you haven't submitted a revalidation within about 2 to 3 months before it's due, they will send you emails and letters to remind you to do it. It absolutely has to be submitted before the deadline, but it does not have to be approved before the deadline. So simply getting that application submitted will stop any sort of negative action. That, you know, once you've submitted it, you absolutely need to track it through to completion. I have lots of people that submit those revalidations and they kind of go into a black hole and nobody thinks about it again. But they do have to be processed to completion, and you need to be responding to requests for information. There is a fee for revalidation. This year it's $709. If you're doing enrollment through PACOS, it will prompt you to pay that before you submit the application. If you're doing a paper application, I provided the link where you go pay that fee, and you need to send proof of payment with your paper application. If you miss your revalidation deadline, my advice is that you prepare and send application either via PACOS or on paper as soon as possible. And they will reactivate you as of the date you submit the application. Now, we have lots of cases where people come to us in this situation. I've missed my revalidation date. Oh my gosh, what do I do? And we help people through that. But if you have missed your revalidation date, the very first thing you should be doing is submitting the application. Then I suggest you get with your counsel. They can help you through that process. And they can also help you manage a situation where you may have a gap in effective dates. And sometimes it's not unusual, especially if they're very short gaps, where we can help people get those eliminated. But something to keep your eye on. Let's go to the next slide. Traps for the unwary. Use PACOS at your own risk. I say that PACOS has been around a long time now, and people really should be familiar and be more skilled at using PACOS. But if you don't use it a lot, it can be daunting. You absolutely can still submit paper applications if that's a process you're more comfortable with. You know, all I say is PACOS isn't perfect. It isn't necessarily intuitive. There are some training videos on the login page for PACOS that are very helpful. The good news is they're getting ready to roll out PACOS 2.0, which is going to change a bunch of stuff. Now that we all know how to use it, they're going to change it. So I use PACOS a lot. I've gotten comfortable with it over the years. And I think the improvements they're planning to make in 2.0 are going to make things faster and easier, especially if you're managing multiple provider enrollment records. But let's say you have home health and hospice and they've got the same ownership. It's going to make some of that simpler. Important things, if you do paper applications, you must deliver your application before the deadline to deliver it passes. So my advice is always to use trackable mail and print your proof of delivery and keep that in a file. If you're using PACOS, make sure you print the application as it was submitted and you keep your submission confirmation. Always keep copies of everything. I keep digital and paper copies a lot of times, and all the attachments that you submitted. If you use US mail, send it certified mail, return receipt, or priority mail or express mail, USPS with signature on delivery. I really want you to be able to prove somebody took it in their hot little hand at Palmetto and accepted delivery of it. And as I said before, if you miss a deadline, send it anyway. Let's go to the next slide. Ashley, refresh my memory. What slide are we on at this point? Are we on 14, 13, or 14?
We're on 14.
14. Okay, I'll finish this one and then I'm going to turn it over to Ashley. So I mentioned earlier that felonies and felony convictions are a hot way to get revoked, and they really are. So felony convictions, CMS is really, really strict about felony convictions. And if you have an owner, managing employee, officer, or director who's had a felony conviction in the previous 10 years, it will get you revoked. they're all reportable on the 855A. The last thing I want people to do is to file a paper or paperless application to report an owner with a felony conviction, because it's just going to result in an automatic revocation. So we try to manage those situations if we know about them timely. Usually we don't. Usually we're getting some kind of revocation after the fact for a provider that's already enrolled, and they found out I had this felony conviction. I didn't even think I had to report it. And then we're really trying to deal with something that can be very burdensome and messy for the agency. But you should understand that there are 4 types of felonies CMS considers detrimental to the Medicare program. These are automatic, like per se things that will get you revoked. Felony crimes against persons, so violent crimes essentially. Felony financial crimes, if it involved money in any way, shape, or form, it falls into this category. Any felony that placed the Medicare program or its beneficiaries at immediate risk, these would be things like convictions for criminal neglect or misconduct. Any felony that would result in mandatory exclusion. Mandatory exclusion is obviously not something CMS oversees, but they are referring in this to the exclusion authority that OIG has. The different set of regulations, but generally it includes the 3 bullets above. So violent crime, financial crime, and something that puts the Medicare program or its beneficiaries at immediate risk. And in addition, mandatory exclusion includes felonies related to the unlawful manufacture, distribution, prescription, or dispensing of a controlled substance. So if a felony conviction falls into one of these 4 categories, it is automatically going to get you revoked. If the person who has a felony conviction is an owner, a managing employee, an officer, or director, and that felony happened within the last 10 years. The best thing to do is to screen people who may be in these roles before they come into these roles and remove them. Either don't hire them or you figure out a way to get them out of the organization. If you're revoked and you remove and submit proof you've removed a person within 15 days of receiving notice of the revocation, CMS will rescind it. You have a very short window of time to do this. I've actually taken advantage of this before, and it has worked. So again, you should be identifying these people before they ever become part of your organization. But if for whatever reason that is not what happens and you do get a revocation notice, you got to act quickly to address it, and you can straighten these problems out. Let's go to the next slide. I'm going to turn things over to Ashley. She's going to talk about operational problems.
Thank you, Jennifer. So yes, we're going to move into the next bucket of ways that you can lose your Medicare number, and it is operational problems. We can go on to the next slide. So the first reason would be for an on-site review or other reliable evidence that requirements are not met. For example, if you do not have good signage at the agency, or you fail to keep regular business hours. So for example, if you have posting of where you're located, this is our address, you have your name posted outside, but then you have your business hours posted as 9 to 5, for example, and a on-site reviewer shows up at the door at 10 o'clock in the morning and no one is there, then that's a problem. That they would say you have a failure to keep your regular business hours. So you need to make sure the business hours that you post are the ones that are correct and that you're actually open at those times. The doors, you know, the doors are unlocked, the lights are on, there's people inside, and also that it's clearly marked at your office. This is our office location, so that people know that this is where your office location has. It's the same thing as having moved. If you are not available at the address where you are at the time you're supposed to be there, then CMS will consider you non-operational and they can revoke you for that. Another reason would be if you have somebody that is excluded or debarred from the federal program. If one of your owners, managing employees, authorized or delegated officials, medical directors, supervising physicians, or other healthcare personnel are excluded or debarred from Medicare, Medicaid, or any other federal healthcare program, or if any of those people or entities are debarred, suspended, or otherwise excluded from participating in any other federal procurement or non-procurement program or activity, you can also be revoked for that reason. So very important that, again, you are screening these people, not just for background checks, not just for felonies, but that you're also screening them for exclusions, not just looking at the OIG-LEIE, but you are also looking at the GSA-SAM and all available state lists as well to ensure that none of these individuals are excluded so that you don't subsequently get revoked for that reason. Next slide. How to prevent, you need to have standardized policies and procedures that you follow. State licensing and federal Medicare regulations require that home health and hospices have signage and post hours of operation and emergency contact numbers. So you need to make sure, not just for Medicare revocation reasons, but also to comply with state licensing requirements, that you have your office hours posted, that you're operational during that time, you have emergency contact numbers, and there's signage for your agency to show that this is where our office is. You also need to treat your office like a retail business. You have to be open to receive patients and surveyors and people from CMS during your regular business hours. You know, think of it as just a regular office where you're treating patients. You wouldn't close down so that everybody can go to lunch or run a personal errand. You need to make sure that there is somebody there in the office to greet people, to welcome people in during your office hours. If for some reason there is an emergency and there is nobody there to cover, post a contact number and the time of return on the door, but that should be reserved for, you know, emergency purposes only. You should have at least one person available during your operating hours at all times. And also, and to tail off of that, plan for emergencies. If your regular receptionist calls in sick, who is the cover person? You have somebody on call for that person that can come in that day. You have a backup plan in the event that there is a problem, that somebody gets sick, that there is an emergency, somebody that can fill in. And also, for the emergency contact number that you list, you need to make sure that somebody actually answers that phone number. You can't just list a phone number and then have it go to voicemail that you never check. You need to have somebody answering that call, and if it does roll to a voicemail, you need to return that message as soon as possible. Next slide. If you do identify somebody that is excluded, similar to what Jennifer was talking about with a felony, if you identify somebody with a felony, if you have somebody that you identify with an exclusion, you should terminate or divest that excluded person proactively. And if you are revoked for that reason, remove that person and deliver proof that you did in fact terminate or remove that person from the company within 15 days after you receive the revocation notice, to cure that revocation reason so that that revocation can get rescinded. Again, like Jennifer said, you know, we have used this before in connection with issues like this, but it is very important that you move very quickly, take very quick proactive action, maintain documentation of the actions that you take, and then submit all that documentation to CMS. You should also focus on standardizing your hiring procedures, which includes current licenses and proof of exclusion screening for every employee. You should be doing screening for your employees and your owners and managing employees before you hire them, and then you should also be screening monthly against the OIG-LEIE, the GSA-SAM, and the state Medicaid list for exclusions. That is actually a recommendation from the OIG that you do it prior to employment and then also monthly thereafter. So if you would not add,
I would just add, Ashley, that if you participate in Texas Medicaid, you are required to do this monthly. That's right. That's right. And you agree that you are doing that. So you don't want to tell Texas Medicaid that you're doing something and then not do it, because then you're essentially not in compliance and could have major problems with the state because of that. If you are using an agency, an outside party to screen your staff and your employees, you need to make sure that they are actually doing what they're supposed to be doing, that you're providing them with updated lists of your staff to make sure that they are screening the right people, and that you have a contract in place with that company that also includes an indemnity clause. You should also screen before you acquire a healthcare business. You don't want to purchase a new company and then find out that they had problems with excluded parties, because that could come back subsequently. Depending on the terms of your transaction, you could be held accountable for overpayments paid to that agency
later on down the road. If you do identify an excluded, debarred, or suspended person, you do need to consider the fact that monies that were paid to the company would be considered an overpayment, and you should absolutely reach out to legal counsel and consider, depending on the overpayment amount, any overpayment would need to be returned either through the OIG's self-disclosure protocol or through a voluntary refund, depending on the dollar amount at issue. If it's under $20,000, you can typically do a voluntary refund, but anything above that threshold would need to be through the self-disclosure protocol that has to be submitted to the OIG. So it's important that you do take that corrective action. If you do find yourself with an excluded party, I would absolutely recommend reaching out to counsel before turning in that voluntary refund or self-disclosure, but it is important to take that affirmative step and keep documentation of that compliant step that you took in the event that this comes up as a question or a revocation later on down the road. Next slide. Okay, we're going to move into our third bucket for ways that you can lose your Medicare number, and this one is going to be related to billing problems. We can go ahead and go on to the next slide. So revocation reason number 8, abuse of billing privileges, and specifically a pattern or practice of billing errors. As Jennifer said earlier during the presentation, we've seen a lot of action under this revocation reason in the last couple years. CMS has broad authority to determine if there is a pattern or practice of billing errors. The factors can include the denial rate on your claims, the reasons your claims are being denied, the provider's history of final adverse actions and the nature of any such actions, the length of time over which the pattern has continued, how long you have been enrolled in Medicare, and then my favorite reason is any other information regarding the provider or supplier's specific circumstances that CMS deems relevant to its determination as to whether the provider or supplier has or has not engaged in the pattern or practice described in this paragraph. So essentially, anything else that they think is important, they can consider in their determination as to whether or not you have a pattern or practice of billing errors. This is driven by data mining and audit activity by the Medicare administrative contractors and by the UPICs, the Unified Program Integrity Contractors. Typically, we are seeing providers who have had prior UPIC audits specifically that have either not been appealed and the provider has just paid the overpayment back and not challenged the UPIC's determination, or they've appealed and been unsuccessful, and then they have subsequent UPIC appeals, UPIC audits that are also unsuccessful. Then we see the MAC come in and revoke that agency, saying you've had several audits where you had the same issues in the audit, you failed to take corrective action, you're still billing the same way, we're revoking you. This is a big deal. To survive this type of revocation, the provider often has to pursue a claim appeal and a revocation appeal, because in the instances where we have seen this revocation, typically there has just been another UPIC audit. And so the provider is getting a revocation letter and a UPIC decision at the same time. And in many instances, it can be a large UPIC overpayment decision. So you are having to not only go through the administrative appeals process for the overpayment, but you're also having to appeal the revocation while you are revoked and not getting paid by Medicare. It can be very stressful and expensive as well while you're trying to appeal audits and you can no longer see your Medicare patients. It's important, in my opinion, that anytime you get a UPIC decision back, you are reviewing that decision, you are taking any allegations in that letter seriously, you are making sure your billing practices are compliant, and you are appealing those decisions, even if it's a low dollar number. For example, I mean, I've seen providers who've gotten a, $2,000 or $3,000 overpayment and just said, we don't want to use the resources to appeal this, we're just going to pay it. But that can come back to bite you later on if you don't change your billing practices and continue to bill in the same way, and you continue to get audited, continue to get a low dollar value, you can subsequently get revoked. So it's very important that you take these audits seriously, and that in the event you do take corrective action for your billing practices, document. You know, we were notified on this day about concerns about our billing practices. These are the corrective actions that we took, so that you have that. I mean, it's essentially, you know, self-defense or defensive driving. You are documenting all that information so that if something does happen later on, you can present that information. And it would also just be useful in general for a claim appeal to show that, you know, you did receive that education from the UPIC and you made changes in regard to that education. Okay, we can move on to the next slide. We do have some language here that we've seen recently on TPE letters and on UPIC letters. The TPE letters, those come from the Medicare Administrative Contractors, from your MAC if you're going through a targeted program to educate review. And language is right here on the screen. If after 3 rounds of TPE review, there are continued high denials, Palmetto GBA, who is a Medicare Administrative Contractor, I'm sure many of you are familiar with, will refer the provider to CMS for additional action, which may include 100% prepayment review, extrapolation, referral to an auditor, recovery auditor, etc. So they're going to be taking additional action. And then we also are seeing in the UPIC audit results that the UPICs are reminding providers that the regulations do authorize CMS to revoke Medicare billing privileges under certain conditions. In particular, they cite that a provider can be revoked if CMS determines that a provider or supplier has a pattern of submitting claims that fail to meet the Medicare requirements. So they're putting you on notice that if you don't do well during TPE, we can take additional action, and if we determine that you have a pattern of practice of billing errors through these UPIC audits, then we can revoke you. So they're giving you notice. You need to take that notice seriously. You need to take all types of audits seriously, whether that comes from a MAC through targeted program to educate, whether you have a SMRC audit, or whether it's a UPIC audit. Make sure you're taking those seriously and taking corrective action so that you don't subsequently see a revocation. Next slide. So some compliance steps for how to prevent a revocation based on a pattern of practice of billing errors would be really doing internal audits. If you identify a claim error and you can fix it, fix it. If it's within the past year and you can submit a corrected claim, submit a corrected claim. You need to have a compliance program in place. If you do not have one in place, you absolutely need to have one in place. And you should not just be utilizing, you know, some off-the-shelf compliance program that was designed for hospitals. You need one that is designed for your agency, that is tailored to you, looks at state law, looks at Medicare regulations, and make sure that a component of that compliance program is regular claim auditing, whether that's through an outside third party that's doing your auditing or whether that's internal audits. And really it should be both, because you're going to get different results based on who's looking at it. Your internal people are going to understand your billing practices more and may not pick up on the same things that an outside auditor might pick up on. You need to know what your denial reasons are if you're getting claims denied by Medicare. Know what those reasons are and make sure you're appealing claims or take corrective action to reduce those denial reasons. You need to review your clinical staff's notes and provide them feedback on their documentation. Take a look at what your nurses are writing. Are they copying and pasting the same information from note to note, or your PTs? Make sure that they are accurately documenting the services that are provided, so that you don't subsequently have an audit where, you know, it's 3 years later, the nurse is long gone, and you're getting denials for medical necessity because it looks like, you know, there were no changes in the patient status and the services that were being provided were not skilled. You need to go through your entire claim cycle from the record to the claim to the ERA. Does everything match up? We recommend getting some paper ERAs, some remittances from Medicare and other payers to verify that they match what you receive electronically. Believe it or not, we have seen billing issues that everything looks right on the provider side when they submit it, but something happens when the claim goes through the clearinghouse, and that changes the information. So you need to make sure everything looks correct all the way through the claim processing cycle. And also appeal denials. Even low dollar amounts can become revocations if they happen repeatedly. So make sure you have somebody that is reviewing your claims. If you have claims that are denied, appeal them. You typically have 120 days to appeal a claim denial for Medicare. That is plenty of time. Appeal those claims, track them, and make sure you're reducing your error rate. Next slide. Okay, so if your agency receives a revocation letter, what do? What if the worst happens and you are revoked? First thing, you need to identify the actual effective date of the revocation. In some instances, it can be before the date of the revocation letter. For example, we see this quite often in felony convictions. That is typically going to be the date of the actual felony conviction, which in some cases we've seen years before the actual revocation letter is issued. And then you're dealing with an overpayment in addition to the revocation. And I'll talk about that in just a minute. But also for site visits, that is typically also based on the date of the last failed attempt to conduct the site visit. So that is typically also going to be a date before the revocation letter. If you have a revocation based on an excluded party, it's typically the date that that person or entity was excluded. Most other revocations are going to be 30 days from the date of the revocation letter. So at least in those instances, you are being notified that you're going to be revoked on this day. So you have a little bit of time before you are no longer allowed to bill. But in the situations where the revocation is dated prior to the revocation date, you are likely going to start getting demand letters for claims that were billed during that time period. And CMS is going to request that money back. And you will need to appeal those overpayment claims, those overpayment denials, in addition to appealing the revocation. Those are two separate appeals that would need to be pursued. Keep in mind that once you are revoked, you are not going to get paid by Medicare after the revocation effective date. So once that revocation date happens, you can no longer get paid by Medicare, no longer submit claims to Medicare. There are no stays through the appeals process. The only way to get unrevoked and to bill Medicare again is to either have the revocation rescinded or reversed. A lot of times we are asked by providers if they are revoked, am I also still allowed to participate in Medicaid? The regulations say that Medicaid will also revoke you. Whether that happens in practice varies. Based on the state at issue. I have seen instances where a provider does not automatically get revoked by Medicaid, and I have also seen instances where they do. So it depends on the state, but Medicaid is supposed to revoke you if you are revoked by Medicare. Private payer contracts will often also require you to report the revocation, and this is something that also can get reported to the National Practitioner Data Bank, so they'll get notified about it that way if you don't notify them in connection with your contract, and that can be a problem for them because then you're not reporting information to the private payer, so you need to make sure you're looking at those contracts and reporting as needed. And also, if you have an accrediting body, that it likely also needs to be reported to them. Next slide. If you do receive a revocation letter, we recommend that you immediately call your healthcare attorney or find a healthcare lawyer to help you. You should begin discussing the appeal and alternative business arrangements or workarounds that may help keep you in business. This is not a time to try to do it yourself. Your business is on the line. There are very tight timelines for appeal. There are tight timelines to get evidence in. You need to take this very seriously. In regard to the appeal, you have 60 days from the date of receipt of the letter to file a request for reconsideration. And in some cases, if you are revoked under revocation reason A1, for example, for noncompliance, then you have 30 days to file a corrective action plan. Your attorney is going to need as much of that time as possible to gather evidence and prepare the request for reconsideration or the CAP. So it's important that you don't just let this letter sit on your desk for 2 weeks. You immediately identify your attorney, notify them, and get the files to your attorney so they can start working on the appeal. As we discussed earlier, if this involves somebody with a felony or an excluded person, immediately remove that person. You have 15 days after the notice of the revocation to remove that person and submit proof that that person was removed. And then if necessary, for an exclusion, for example, work with your attorney to report your mistake to the OIG via a self-disclosure or do a voluntary refund if necessary. Discuss alternative billing arrangements for Medicare with your attorney. You could consider reducing your Medicare census, and if necessary, transferring patients to other providers. You also want to review your private pay contracts and determine the potential impact. I will say that typically, you know, you're going to continue to get paid by private payer advantage for a little while, but again, you need to make sure you're reporting this information to these plans per your contracts. Develop a plan to address reduction of staff that includes retaining necessary personnel while you transition patients to new providers, but you're likely going to need to terminate some people and reduce your staff while you're going through the revocation process, because many home health agencies and hospices rely heavily on Medicare for their income. And so if you are revoked and no longer receiving income, you're going to need to take action in regard to your staff. And you also need to conduct a realistic financial analysis to determine how long you are going to be able to stay in business. And I know we're at time, so I'm just going to try to quickly go through a few last couple slides if we can move on to the next one. These are the appeal procedures on the next two slides. I'm going to just quickly talk about them. As I stated before, corrective action plans, those are only available for revocations related to reason A1 for non-compliance. You have 30 days. They are optional. If you do have the option to submit a CAP, I highly recommend that you pursue it. You cannot fix a failure to report, but you can address mistakes by the contractors, like failing to acknowledge an update that you sent them. If you can prove delivery, you can sometimes address DME and IDTF standard violation issues through this, and you usually get an answer within 30 to 90 days. I will say that if you are given the opportunity to file a CAP, you still want to submit a request for reconsideration, which is the first level of appeal for a revocation. Filing a CAP, filing a corrective action plan does not stay the appeal timeline for the reconsideration. You have 60 days to file the request for reconsideration. If you fail to file your request for reconsideration within that 60 days, you lose your appeal rights entirely, even if you file the CAP. So very important to get that request for reconsideration filed, even if you're pending the results of a corrective action plan. Another important note for the request for reconsideration, this is your evidentiary milestone. You must get all documentary evidence you want to be considered in connection with your appeal in at this first level of appeal. If you do not get it in at the first level of appeal, you have to show good cause for why you could not provide the documentation. Can be a difficult standard to meet, and typically can only be because the documentation was not available at the time, or there was some sort of emergency that didn't allow you to get that information in. So very important to get your documentary evidence into the record with the reconsideration appeal. And again, why you're going to want to notify your attorney as soon as possible so that they can start gathering everything that they need. You do usually get a decision within 90 days. It does typically take that entire time to get a decision. And you need to make sure that you make all factual and legal arguments in your request for reconsideration, and you address all of the revocation reasons, not just if there's more than one, you need to address every single one, because you could get an overturned decision on one, but not another. So you need to make, and then you're still revoked. So you need to make sure if there's multiple revocation reasons, you address all of them. Next slide. If you are unsuccessful at reconsideration, you do have the opportunity to file a request for hearing before the Civil Remedies Division of the Departmental Appeals Board. You have 60 days from the date of the reconsideration decision to file that appeal. We do recommend getting an attorney if you did not have an attorney for the prior level of appeal. For this level, CMS is going to be represented by attorneys at this level and will be making legal and evidentiary arguments in support of their case. There's a formal briefing process, formal court procedures. If you do have a hearing, it can include cross-examination of witnesses. So important, if you did not get an attorney for the first level, even though we highly recommend it for that level as well, you should get one if you decide to proceed to a Departmental Appeals Board appeal. The rules say they try to resolve these cases within 180 days. Can take longer, although These cases do typically follow a better timeline of resolution as opposed to the claim appeals that can pen for a much longer period of time. If you are unsuccessful at the Department of Appeals Board Civil Remedies Division for the ALJs, you can subsequently appeal to the Department of Appeals Board Appellate Division. Again, that is before a panel of judges. It is typically on the record. They're reviewing a paper appeal and the administrative record. Again, I would highly recommend having an attorney for that level of appeal as well. You have 60 days to file that appeal after your decision is issued by the administrative law judge at the prior level. And you can still also appeal to federal court if you have an unfavorable appellate division decision. That, again, you also have 60 days for that. I will say that in many of these situations, it is difficult to win because a lot of discretion is given to CMS in determining why a provider can be revoked. They are very hard cases to argue and win. We have had a lot of success with these cases, but it is a very difficult appeal. You have to point out specific facts where the, that the agency got wrong, and point out, specific pieces of evidence for the agency to consider. So I highly recommend, again, working with an attorney closely if you are revoked. Next slide.
And I would just add to Ashley's, and I want to go through the stay of enrollment. I want her to go cover that. But I would say the cases Ashley and I handle, 90+% of them, if they're not resolved at reconsideration, we take them to the second level of appeal, and we try to settle the cases. When it gets to the Civil Remedies Division, there's an actual attorney from the HHS Office of General Counsel that represents CMS, and we can negotiate with them. It's the first opportunity for an attorney on your side to talk to an attorney on their side. And we find that if we're going to get a favorable resolution, that's where we get it. And we usually get it through settlement, not through litigation. So just something to keep in mind.
Jennifer. Okay, and one last point before we check for questions is the new stay of enrollment. There was a new regulation at 42 CFR 424.541, and CMS also issued an MLM Matters article about this new stay of enrollment, which indicated that contractors can start using the stay of enrollment as of May 30th, 2024. I have not personally seen any yet, but they do now have authority to utilize this new tool. This would be less burdensome than a deactivation or a revocation of your Medicare enrollment. It is a preliminary interim status representing there is a pause in enrollment. It does not require a full initial application as a new provider to remove the stay and reactivate billing privileges like a deactivation would, for example, or if you are revoked and then have to subsequently reapply for Medicare. This is just going to put a pause on your enrollment. This would be available for CMS to use where a provider is considered non-compliant with at least one Medicare enrollment requirement, and can remedy the non-compliance by submitting an enrollment form, for example, in CMS 855, to show where they are, in fact, in compliance or to fix the issue. Some examples would be a failure to report a change of address, a failure to timely revalidate, a failure to report the deletion of a managing employee. Some key points are that you remain enrolled during the stay. You are not deactivated, you are not revoked, you are enrolled. But your claims will be rejected during the stay period, and the stay period is not going to be longer than 60 days. So you need to act quickly to respond to the deactivation to try to resolve the issue before the 60-day period expires. This is also not going to be considered an adverse legal action that would need to be reported to Medicaid or to your private payers, for example. And it can be imposed multiple times. So if you have a stay of enrollment for a failure to report a change of address, you resolve that, then subsequently, a little while later, you fail to timely revalidate, you can have another stay of enrollment for that. But this is, I think, a good thing for providers because a failure to report a change of address we used to see a lot of revocations for that, and that is a hard revocation reason to overcome. And if you are revoked for that reason and you cannot show that you did in fact timely report your change of address, then you are not only revoked, there is typically a re-enrollment bar associated with that revocation, and you cannot re-enroll for at least typically a year. So this is a good thing for providers so that you can remedy small errors and failures to report information or revalidate instead of being deactivated or revoked and not able to participate in Medicare until the issue is resolved. So like I said,
I would just echo what Ashley's saying, that we've been begging for something like this for years as a less burdensome, less onerous, less punitive way to fix basically failures to update your enrollment form. So I'm actually happy to see this and look forward to working with clients that may get these letters. And I really do hope the contractors use it and take it seriously.
Absolutely. And then I think we can go on to the last slide. And do we have any questions, Gabe or Gio?
Yes, we do. Just give me 1 second. So yeah, one of the questions is, what if we are in the process in obtaining a new medical director?
Medical directors are required to be reported now for hospice. So if you're replacing your medical director, you're going to need to submit a change of information to add your new medical director to your enrollment record if this is for hospice.
Okay, the next question is, if a home health provider failed to submit notifications of change in information or change in individual control in a timely manner, well over 30 days, over a year, what penalty a home health provider should expect after the charge of information?
After the change of information is submitted. Yeah, I mean, it's a common question we get, and my response is, you absolutely still need to do the report. And I would say my experience, and I do a lot of enrollment work, has been that they accept it and move on. I haven't seen anybody punished or revoked for cleaning up their enrollment record. Generally speaking, they want you to do that, and we have not seen bad things happen when you report it late. Now, that's not to say that the regulatory provisions don't exist for something to happen, but in practice, I have not seen CMS take action when you report things late.
The next one is, going back to felonies, does something like a felony DWI that occurred 8 years ago need to be reported?
If you find yourself in that situation, my advice is to get with counsel. I have had situations where DUIs have resulted in revocations, usually of individual providers, like physicians, physician assistants, nurse practitioners. I think that's something you need to discuss with counsel, and if that's the scenario you find yourself in, you need to do it quickly.
Mm-hmm.
All right, and the last question is, when discussing UPIC appeals, would you go all the way to the ALJ level? And what if the provider doesn't believe it will pass the ALJ level?
Well, you have to take a look at, what the underlying denial reasons are, the strength of your arguments in support of those claims. If you don't think your appeal is going to be successful, and you're essentially in a situation where you're filing a frivolous appeal, then that's something that you need to consider. But you also need to make sure you are taking the corrective action that you need to take. If the UPIC is right, you're taking corrective action, and you're no longer billing in the same manner that caused the claim denials in the first place, and that you're documenting the changes that you made, so that if you are subsequently audited, a UPIC doesn't think that you're still just continuing on disregarding what the UPIC said previously. That's what's going to get you into trouble with a revocation. So I do understand that, if you don't think an appeal is going to be fruitful because they're right, that can be a different situation, but you still need to make sure you're actually taking corrective action, documenting that, so that you can show later on that we did take this seriously and didn't just continue on and ignore what the UPIC said.
And I would just add to that, we're not necessarily seeing situations where one bad audit that doesn't have other facts that are complicating it are necessarily leading to revocation, because we have providers, we talk to people every day who are going through an audit and they are not revoked. I think I just would echo again what Ashley just said. If you have a bad audit, the key is, what do you learn from it? How do you improve, and document how you're going about that so that you don't have a second one. And if you're in TPE and you're on to round 3 and you're still having problems, you need to take a really hard look at how you're managing your business, who are in certain roles, why are you not improving? Because while we haven't necessarily seen a TPE, a third bad round of TPE result in a revocation, we have seen them referred for UPIC. And I all of these, every scenario is unique, and every, and CMS is a dynamic organization that changes how they interpret and apply these things, because many of these revocation reasons are discretionary. So just because we saw it happen one way over the last 5 years doesn't necessarily mean it's going to be the same in the next 5 years. So I think the key with the pattern and practice of billing errors or a bad UPIC audit is, as Ashley said, how do you prevent it from happening again? And if you can appeal, you do.
Well, I think that was the last question. So that concludes today's webinar. I do apologize for the technical difficulties that we had at the beginning. But thank you for joining us, and thank you to our speakers, Ashley Morgan and Jennifer Papapanagiotou. Everyone from today's webinar will receive a copy of the presentation tomorrow via email. And if you have any further questions about today's discussion or another healthcare law issue, please feel free to reach out to Ashley or Jennifer, or to Lyles Parker itself. And have a good Wednesday. Take care.
Thank you.